Okay, picture this. A sudden knock at the door. It's a moment of really high tension, right? But what are the actual on-the-books rules that govern what happens next? Welcome, everyone, to this explainer. My goal today is to draft a really detailed narrative explaining the presentation attached, so that all these dense concepts and content are clearly understood. We're going to break down exactly how criminal procedures work under the BNSS. That's the Bharatiya Nagarik Suriksha Sanhitha. We'll be looking at search, seizure, and how investigations actually wrap up. So let's just dive right into this structured journey through the reality of criminal procedures.
Let's kick things off with a little thought experiment, shall we? You've got a locked door. What exactly happens when law enforcement needs to get behind it? We always see these super dramatic representations in movies where doors just get kicked in. But the legal reality? It's a highly structured process governed by very specific, rigid rules. A locked door isn't just a piece of wood or metal. It literally represents a fundamental boundary between state power and your individual privacy.
And under sections 96 and 103 of the BNSS, an unopened door is the physical threshold where legal theory meets the real world. A search warrant is basically the key that opens this door. But how that key is turned, and what happens if the person inside just flat out refuses to open up, well, that is where the law gets incredibly specific. Let's look at the exact steps involved.
To make this crystal clear, here is the exact chronological roadmap for our explainer today. We're going to cover demanding evidence, executing legal searches, evaluating evidence, filing the police report, and finally, protests and further investigations.
Okay, step 1, demanding documents and evidence. This is the initiation of the investigation. Actually, scratch that whole knocking on the door image for a second. Before the police ever show up at a property, they usually start by gathering a paper trail and digital footprints. Under Section 94, a court or an officer in charge of a police station can issue what's called a summons to produce. Basically, if they think a document or an item is absolutely crucial for an investigation, they can issue a written order demanding it. Now, what's really fascinating about this provision is how modernized it is. It covers your standard physical documents, sure, but it explicitly includes electronic communications and digital devices. Another wild detail? If you receive one of these summons, you don't even have to show up in person. No sitting in a sweaty interrogation room. Simply emailing the requested digital file or sending the device over to the authorities totally fulfills your legal duty. Moving right along to Part 2, executing legal searches. Let's see how things escalate from a passive summons to an active police operation.
So, we are back at that locked door we talked about, operating under Section 103. If the police need to search a closed property, they can't just go full action movie and bash it down immediately. The statute lays out a very clear 3-step escalation protocol. First, they have to ask the person in charge to allow free entry and provide reasonable facilities for the search. Second, the police must actually physically show the search warrant to the occupant. But what if they say no? What if entry is denied? That leads to Step 3. Only then is the officer permitted to break open the door, and even then, they must use only reasonable force. It turns a really dense legal statute into a clear, step-by-step action plan that protects both the investigation and the citizen.
Now, you might be wondering, how do we know they actually followed those rules once they got inside? Well, this is where the BNSS brings things into the 21st century. Under Sections 105 and 185, searches and the preparation of seizure lists must now be recorded using audio-video electronic means. And the law actually notes a preference for using a mobile phone. The police officer has to capture the actual search proceedings, the listing of the seized items, and the signatures of independent witnesses right there on camera. This recording is then forwarded to the magistrate without delay. So if your property is ever searched, there's an objective, unblinking digital eye making sure your rights are completely respected. It's a real game changer for accountability. All right, that brings us to Section 3, evaluating the gathered evidence. Let's see how courts actually view these police actions in practice. We've got to pause the procedural timeline for a second to look at what happens when the evidence gathered by the police is put to the test in court. Take the case of Pradeep Nairant Madgankar versus the state of Maharashtra. The defense argued, hey, you shouldn't be able to convict someone purely on the word of the police officials who did the search, especially without independent witnesses. But the Supreme Court stepped in with a bit of a reality check. Think of it this way. A rule of law is a strict, unbreakable requirement. The court said independent corroboration isn't that. It's a rule of prudence, which means it's just really good common sense. A police officer's word isn't automatically thrown out. Judges definitely prefer having a neutral bystander back up the story, for sure. But if the officer's testimony is undeniably trustworthy on its own, a conviction can totally stand.
And on the flip side of that coin, we have the case of Manish Dixit versus the state of Rajasthan. This dealt with circumstantial evidence. The Supreme Court laid down a super powerful reminder with this quote right here. They stated, "The circumstances must form a complete chain. The evidence created suspicion, but did not meet the standard of proof beyond reasonable doubt." The key takeaway: police can gather an absolute mountain of circumstantial evidence, but if there is even a single broken link in that chain, it's just suspicion. If one piece of the puzzle is missing, the state cannot take away a person's liberty. To actually secure a conviction, the chain connecting the accused to the crime has to be absolutely unbroken. Okay, moving into Section 4, filing the police report. This is basically the climax of the whole investigation. So under Section 193, we get the police report, which most people know as the charge sheet. The golden rule here is that it has to be filed without unnecessary delay, which ties straight into your Article 21, right to a speedy and fair trial. The charge sheet has the whole shebang: names, facts, witnesses, and whether the accused is in custody or on bail. Also, there's a strict requirement for medical reports and sexual offenses. But here is the really interesting part. There is a brand new BNSS requirement to explicitly document the chain of custody for any electronic devices seized. Why does that matter? Because a smartphone is packed with data that is super easy to manipulate. Documenting exactly who held that phone and when stops digital evidence from being tampered with before trial. And to top it off, indexed copies of all this have to be supplied to the accused electronically. Because justice delayed is justice denied, right? Section 193 lays down some incredibly strict deadlines. Let's check out this timeline. For serious sexual offenses under the BNS, or the POCSO Act, police have a hard 2-month limit to wrap up their investigation from the time the FIR is recorded. Plus, within exactly 90 days, the police are legally required to update the informant or victim on how the investigation is going. And finally, if they need to do further investigation while a trial is happening, that also has a 90-day limit, unless a court specifically grants an extension. Time limits like these are what keep the wheels of justice actually turning. Which leads us to our final section, number 5, protests and further investigations, the aftermath of it all.
Imagine this scenario, defined by the landmark case Bhagwant Singh versus Commissioner of Police. The police finish their investigation and they file a closure report. Basically, they tell the court, hey, there's no case here. The magistrate looks at this and has 3 options. Option 1, accept the report, case closed. Option 2, disagree with the police completely and take cognizance of the offense anyway. Option 3, order the police to go back and investigate more. But here is the absolute mandatory rule the Supreme Court established. Before a magistrate can ever choose option 1 and close a case, they have to give notice and a proper hearing to the informant or complainant. This is a massive safeguard. It means the police can't just quietly sweep an investigation under the rug. The victim always gets the chance to protest before a judge shuts the door for good.
And to wrap up the case law, let's quickly look at Pramod Kumar versus the state of UP. Let's say the police file a charge sheet, the court takes over, and the trial is underway. But suddenly, the police want to investigate a brand new angle. Can they just restart the investigation on their own? The court was very clear, absolutely not. Once that charge sheet is filed and the court takes over, the police lose their unilateral power to just keep investigating. They have to get prior leave, basically permission, from the court under Section 193.9 of the BNSS. The court becomes the ultimate gatekeeper.